2154. Hey, how are you?
Good, how are you guys?
Good.
These guys are all.
There.
They're prepared.
Oh, they're all in the back.
I thought it was you guys that were talking. I got munchkins if anyone wants some.
Where at?
In Laura's office.
Nice.
I think she.
committee will come to order. Without objection, the chair is authorized to declare a recess at any time. Once again, we find ourselves at a hearing examining the management failures at the EPA. We've seen numerous examples of fraud, unprofessional behavior, cronyism, and outright theft at the EPA. The most egregious example of this involved Mr. John Beal. Mr. Beal did not work for a decade while claiming to work for the CIA, a complete lie that his supervisors blindly accepted as fact. This is just one example among many of the glaring management failures at the EPA. It is well past time that someone be held accountable for these management failures. And today, we will discuss more problems concerning EPA employees, including the outrageous behavior of now retired EPA employee Peter Jutro. Mr. Jutro was the acting associate administrator for the EPA Office of Homeland Security. He also happens to be a serial sexual harasser. As a result of an Inspector General investigation, we now know that Mr. Jutro sexually harassed at least 16 women while working at the EPA. Even worse, EPA senior management was aware of his history of harassing women, but continued to promote him. EPA management never even took the time to talk to his direct supervisor, who had verbally warned Mr. Jutro several times about his unacceptable behavior. In essence, there was no consequence for this abhorrent behavior. By turning a blind eye, EPA management allowed at least 6 more women to be harassed by Mr. Jutro, and we know this because of the good work by the men and women who serve as in the Inspector General's office. When Mr. Jutro was finally placed on paid leave, he quickly retired with full pension benefits to avoid being interviewed by the IG about these allegations. And part of what I hope we look for in this committee moving forward are ways that the Inspector General can continue their investigation and continue to be able to compel somebody to participate in their investigation, pardon me, in their investigations, that they can't just simply retire and get a get-out-of-jail-free card. In addition to Mr. Jutro, there are continued problems with EPA employees who watch pornography at work. To date, we are aware of 2 employees who have admitted to watching pornography several hours each and every day. It's a miracle they did any work at all, and maybe they did. Maybe they didn't. We don't know. Even more insulting to taxpayers is that after the Inspector General reported these abuses, the porn-watching employees were placed on paid administrative leave for almost a year before anybody even tried to fire them. Now, these people were being paid roughly in the neighborhood of about $120,000 a year. One of these employees finally retired after almost a year of paid leave. The other employee is still collecting his government salary, and he, too, has been on paid administrative leave for almost a year. The American taxpayers continue to pay this person. If you're sitting there watching hours of porn on your government computer, fire them. Fire them. Then let them try to come back and claw. But there's so much overwhelming evidence about what these people were doing. This pattern of paid administrative leave followed by retirement with full benefits is totally and wholly unacceptable. It rewards bad behavior and leaves taxpayers footing the bill. Now, it is totally unfair to suggest that most, all, or anything in between of these employees are participating in this abhorrent behavior. Most of the people, the overwhelming majority of the people who work at the EPA and other departments and agencies within the federal government, they're good, honest, decent people working hard. They're trying to do the right thing. They're patriotic in their approach. But I think we as a body, as an institution, that the EPA and others, the Congress, we have a duty and obligation to the American taxpayer to fire the people who are abusing the system. Get rid of them. Kick them out of there. But that doesn't seem to happen. In the EPA, from our viewpoint, our perch here, you know, we've got some good inspector generals who've done some good quality work here. But when we know about these people who are participating in sexual harassment more than a dozen times, and that person isn't fired, that's a huge problem. A lot of good people work at the EPA, and they do a lot of good, important work. But when we have a bad apple, we've got to get rid of them. Some of these good employees became victims of harassment due to these continued management failures. And that's the sad thing. You know, somebody's going to do something stupid, but if you don't take care of it immediately the first time, then there are more victims. And that's the case, and that's why we're here today. In addition, high-performing employees become discouraged when they see management rewarding bad behavior or ignoring clear signs of misconduct. There can be probably nothing more demoralizing than knowing that somebody has this problem, it's affecting others, nothing's done about it, and then they get promoted. So the committee will continue to look at exploring legislative solutions to encourage agencies to weed out the bad actors while protecting the rights of the vast majority of good employees, creating a good, positive work environment so that we can get the job done. And we as a nation, I say this several times, we look at these things in an open, transparent way, and we do so in the effort to make it better. And that's why we have this panel here today. Now recognize the ranking member, Mr. Cummings, for 5 minutes.
Thank you very much, Mr. Chairman. Mr. Chairman, before I begin, I would like to take a minute to thank you, Mr. Chairman, for your leadership. Over the last few days, we've had all kinds of things in the news, but one thing that kind of slipped under the rug for many reasons is that the NFL's decision to waive its tax-exempt status. Mr. Chairman, you worked very hard on that. And you called a bipartisan meeting, and you and I sat down with NFL folks, and you let them know that in a bipartisan way we were concerned about this issue. I know that you've filed legislation, and something that's very near and dear to you. And I know a lot of people are going to take credit for it, or try to. But I got to tell you that, you know, so often these things that are done without legislation, when we sit down and we work together, we can accomplish. And I compliment you and your staff for that. And I'm hoping that the NFL understands that we had at least 2 other issues that we were concerned about, and that was the whole thing of concussions, and we wanted to deal with look at what they are doing with regard to abuse, spousal abuse, relationship abuse, and those kinds of things. But I just wanted to compliment you and thank you for your leadership on that.
The gentleman yield.
Yes, of course.
Thank you. I appreciate it, and I think it does demonstrate that in a bipartisan way we can be more effective, even if it's behind the scenes. And I appreciate those comments because we did this in unison, and it had the desired effect. And we appreciate the NFL for taking the proactive nature and making this adjustment. I think it is the right thing to do. It's the fair thing to do. And again, our thoughts and prayers are with you. I don't know how you're here. I turn on the television, you're up in Baltimore dealing with some very difficult situations, and admirable what you're doing to talk about the calm and the peace, and I admire you for what you're doing and how you're doing it. You're making us proud, and again, our thoughts, hearts, and prayers with you, and I'm just amazed that you're able to be here this morning, but I thank you for being here.
Thank you very much, Mr. Chairman. Now, thank you, and I thank you, too, for calling today's hearing. Let me start by making a key point that I know we all agree on. The overwhelming majority of federal workers are extremely hardworking, and many devote their entire lives to serving this nation. We recognize their service to our country, and we honor and we thank them. And one of the things that the chairman was saying just a moment ago, when we have cases like the ones that we are addressing today, it only goes against the morale of those great employees. And it also, we want to make sure we don't tarnish their great reputations by the conduct of a few. We also know that with a workforce of millions of people, there are bound to be individuals who waste government resources, squander taxpayer dollars, violate the law, unfortunately, and fail in their core responsibilities as employees of this great United States of America. Today, we will focus on a handful of these employees who worked at the Environmental Protection Agency and abused the public trust by viewing pornography at work. In each case, the employee signed a sworn statement admitting to this misconduct. We have now obtained these sworn admissions, and based on their own words, nobody else's but their own words, there is no doubt that these employees should have been fired. No doubt whatsoever. So the questions for today's hearing are these. Why were some employees fired quickly while others were allowed to stay in their jobs for a long time? Something is wrong with that picture. Why was there inconsistency in removing these employees? And are there ways to improve this process going forward? One of the things that the chairman and I have discussed with regards to some other agencies is when you have employees that are treated one way and others that are treated another way, it kills morale. It kills it. People just want a level playground, ground they want to act on. They want to know that if they do something right, they are applauded just like everybody else. If they do something wrong, they want to know that they're going to be disciplined just like everybody else. And they can accept that because those are the rules. But when they see a deviation, that's a problem. So based on the documents the committee has obtained, I do not believe we need more legislation to address this issue, and I certainly want to hear from our witnesses on that. Instead, I believe the EPA, the Inspector General, and the Department of Justice need to coordinate and share information more freely and more quickly. For example, EPA and IG officials responded very quickly in the case of Thomas Manning, a computer specialist in Chicago regional office who admitted possessing child pornography. He admitted it. The EPA notified the IG of possible criminal conduct on March 13th, 2013. The next day, the IG obtained Mr. Manning's sworn statement in which he admitted that he looked at, quote, child pornography on the EPA computer, end of quote. On that same day, the EPA placed this employee on administrative leave, same day, blocked his access to EPA servers, and barred him from EPA buildings, same day. A month later, on April 10th, the EPA placed him on indefinite suspension without pay. On August 5th, the IG provided the EPA with a copy of the employee's sworn admission, and the agency initiated termination proceedings. He later pled guilty to possessing child pornography and was sentenced to 30 months in federal prison. In other cases, however, this process took much, much longer. For example, on September 11, 2013, the IG received a complaint that a GS-14 geologist had downloaded thousands of pornographic images into EPA servers. 1 week later, IG agents went to talk to this employee and personally observed him viewing pornographic images on his work computer. The same day, this employee signed a sworn admission in which he explained how much time he spent at work surfing the internet for pornographic images. Although he stated that, and I quote, it varied from day to day, end of quote, he admitted that on days when he had little work to do, quote, the surfing may be as much as 5 to 6 hours per day. A workday is only 8 hours. This, to me, this sworn admission of wrongdoing by the employee should have been enough to initiate termination proceedings against him. However, the IG did not provide a copy of the admission to the EPA for at least 9 months. And even then, nearly a year and a half passed before the EPA finally issued a notice to remove him. As I close, there was a similar delay in another case when a GS-14 employee, an environmental specialist, admitted to the IG that he had also viewed pornographic images while at work. The IG also obtained a sworn statement from this employee in which he admitted looking at pornographic pictures for up to an hour per day. Yet the EPA did not initiate removal action until 10 months after the employee admitted to this misconduct. I understand that the decisions in these cases may have been affected by ongoing criminal investigations by the U.S. Attorney, and there may have been restrictions on what evidence could be shared with and when. But if an employee admits to misconduct, if he actually signs a sworn statement detailing what he did wrong, it seems to me, now maybe I'm missing something, that we should be able to share that information immediately so the agency can use it in a termination proceeding. So, Mr. Chairman, I thank you for calling today's hearing, and I hope we can work together to develop concrete proposals to speed up this process, increase information sharing, and ensure the EPA and the IG and the Department of Justice all have the ability to use as much evidence as possible against an employee who engage in this type of activity. And with that, Mr. Chairman, I thank you for your courtesy, and I yield back. Thank you.
I hope those from the EPA understand the outrage we have on both sides of the aisle. This is totally and wholly unacceptable. This will be a good hearing, and I appreciate your participation. I will hold the record open for 5 legislative days for any members who'd like to submit a written statement, but we'll now recognize our panel of witnesses. We're pleased to welcome back to the committee, who's testified many times before us. We always appreciate having the Honorable Arthur Elkins, Inspector General at the Office of Inspector General at the United States Environmental Protection Agency. Mr. Patrick Sullivan, Assistant Inspector General for Investigations at the Office of Inspector General at the U.S. EPA. Mr. Stanley Myberg, the Acting Deputy Administrator at the United States Environmental Protection Agency, and Mr. John Reeder, Deputy Chief of Staff at the EPA. Welcome all. Pursuant to committee rules, all members or all witnesses to be sworn before they testify. If you will please stand and raise your right hand. Do you solemnly swear or affirm that you will tell the truth, the whole truth, and nothing but the truth? Thank you. Witnesses may be seated, and let the record reflect that all witnesses answered in the affirmative. In order to allow time for discussion, we would appreciate if you limit your opening statements to 5 minutes, but we're pretty liberal on that policy. And again, your entire written statements will be entered and made part of the record. My understanding is, Mr. Reeder, you've combined your statement with Mr. Myberg, and so we'll start with Mr. Elkins and go from there. Thank you. Mr. Elkins.
Good morning, Chairman Chaffetz, Ranking Member Cummings, and members of the committee. I am Arthur Elkins, Inspector General of the EPA. I will discuss 2 matters. First, I will report on the current status of impediments arising from the EPA's Office of Homeland Security. And second, I will discuss the importance of immediately reporting all employee misconduct to the OIG. During a September 2014 hearing before this committee, I testified that the EPA had asserted there was a category of activity defined as intelligence to which the OIG may have access only subject to the EPA's granting of permission. This situation impeded the OIG's ability to investigate threats against EPA employees and facilities, conduct certain misconduct investigations, and investigate computer intrusions. Since that hearing, senior OIG officials have met multiple times with senior agency officials to address a range of issues falling under these general categories. We have theoretically agreed that there is no category of activity at EPA to which the OIG does not have unfettered access. However, at least 2 crucial impediments remain. First is a 2012 MOU that EPA had entered into unilaterally with the FBI. EPA asserted that the MOU precluded it from sharing information with the OIG. However, FBI senior management has since confirmed to EPA that the FBI does not require withholding information from the OIG. During meetings with EPA, we have stated that any MOU addressing these issues must be a 3-way MOU among EPA, OIG, and the FBI. EPA has not rescinded the existing MOU, even though its terms allow the agency unilaterally to rescind it anytime it chooses. Nor has the agency accepted our proposed elements for a revised MOU. The second crucial OHS-related impediment is that OHS continues to have a use of criminal investigators while lacking any investigative authority. The OHS examples are fundamental challenges to the legal authority of the OIG to do its job. Under the theory being pursued by Administrator McCarthy, The head of an agency could preclude an IG from exercising responsibilities and authorities assigned under the IG Act by simply declaring that because an activity falls within an agency program or operation, that activity is exempt from OIG jurisdiction. Agency heads would be empowered to decide when the IG Act is applicable and when it is not. If accepted, this approach would allow an agency to create out of whole cloth unilateral exemptions to the IG Act, where no such exemptions currently exist. Late yesterday afternoon, I received 2 emails from the administrator advising of an imminent withdrawal of the MOU. While I sincerely appreciate the spirit of the proposal, the stated terms fall disappointingly short of addressing the OIG's concerns. So without real clarity in this matter, we unfortunately continue to operate in a fog. This is the current state of affairs at EPA. While Mr. Sullivan's testimony will address in greater detail the Peter Utro investigation that the committee has asked about, I want to address that case with a broader view as to why it matters relative to the OIG's oversight role. We found that an SES-level EPA employee engaged in offensive and inappropriate behavior toward at least 16 women, most of whom were EPA coworkers. Further, we found that very senior EPA officials in the administrator's office were made aware of many of these actions and yet did nothing. They did not tell the administrator, and they did not report any of this knowledge to the OIG. In fact, they approved Utro for a detail assignment to be acting associate administrator for OHS. Subsequently, Utro engaged in such behavior toward an additional 6 women. The necessary implication of the overall structure and certain explicit provisions in the IG Act is that the OIG will only be able to carry out its statutorily assigned functions if it receives cooperation from the agency. Further, both the current and previous EPA administrators have sent memorandums to the entire EPA workforce setting forth an expectation of cooperation with the OIG. The OIG's investigation was negatively impacted and delayed by the fact that these senior EPA officials did not notify the OIG about their knowledge of underlying incidents. This is not the first time that I have raised an alarm in regards to these issues to EPA leaders and at congressional hearings over the past 5 years. By this time, I have to question the priority or the sense of urgency on the part of agency leaders to resolve these issues. Cooperation, unlimited access, and immediately reporting fraud, waste, and abuse to the OIG are necessary tools that enable an OIG to fully accomplish its mission. Yet, OIGs have control over none of these tools, nor, ultimately, can we compel solutions. It is essential that the tenets of the statute directing the OIG's work remain intact, well-supported, and not subject to arbitrary revisions by agency heads. Finally, I want to reiterate my appreciation for this committee's support in that regard. Mr. Chairman, I would be pleased to answer any questions that you or committee members may have.
Thank you, Mr. Elkins. Mr. Sullivan, you're now recognized for 5 minutes.
Good morning, Chairman Chaffetz, Ranking Member Cummings, and members of the committee. I am Patrick Sullivan, Assistant Inspector General for Investigations for the EPA. My testimony will highlight several cases of EPA employees who viewed and downloaded pornography on government-issued computers, as well as our investigation of a senior-level EPA official who exhibited inappropriate behavior towards several women over many years. First, I will discuss Employee A, who downloaded more than 7,000 potentially pornographic files into an EPA server. In September 2013, an OIG special agent went to the employee's work location and observed the employee viewing adult pornography. The employee admitted that for approximately 2 to 6 hours daily during his assigned work hours, he had viewed and downloaded pornographic images on an EPA computer. We reviewed his laptop and discovered about 20,000 additional pornographic files. The employee advised that he was not doing anything wrong by accessing pornographic websites since he was completing his required work. During the period he viewed the pornography, he received several performance awards, including awards up to $2,000 and a time-off award. He was then placed on administrative leave by EPA in May of 2013. In March of 2015, the U.S. Attorney's Office declined prosecution. Earlier this month, EPA notified us that the employee had retired. Next, I will discuss Employee B, who had been witness viewing pornography on his government laptop computer during work hours by a child who happened to be visiting the office during Bring Your Daughters and Sons to Work Day. The employee admitted that he viewed pornography at work between 1 to 4 hours per day. He stated that approximately 30 to 40% of the data stored on his external electronic media devices contained pornography. Approximately 3,500 pornographic images were recovered from the employee's laptop and external media. EPA placed the employee on paid administrative leave in May of 2014. In March 2015, the U.S. Attorney's Office declined this case for prosecution. Last month, the EPA notified us that the employee had been proposed for removal. The third investigation involves Thomas Manning, an IT specialist who downloaded child pornography. He admitted to viewing child pornography on the EPA computer and attempted to erase it afterward. We found that Manning also possessed tens of thousands of images of child pornography on a personal hard drive stored at work. He resigned while under investigation in August 2013. He later pleaded guilty in July of 2014 to possession of child pornography. Earlier this month, Manning was sentenced to 30 months in federal prison to be followed by 5 years of supervised release. Lastly, I would like to discuss our investigation involving Peter Utro. In August 2014, we received an allegation that Utro, the acting associate administrator for the EPA Office of Homeland Security, engaged in a series of interactions involving a 21-year-old female intern from the Smithsonian Institution. The OIG's allegations and findings included the following. In July of 2014, Utro engaged in interactions involving a 21-year-old female intern who reported them to her supervisor and indicated that she was uncomfortable and scared. In his office, he asked the intern what turned her on and what excited her. He also took photographs of the intern's face and toes. Contrary to the intern's statement, Utro denied brushing up against, attempting to kiss, or grabbing the intern's buttocks, but he conceded he might have placed his hand on her back. From 2004 through July of 2014, Utro engaged in unwelcome conduct with 16 additional females, including touching, hugging, kissing, photographing, and making double entendre comments with sexual connotations. We substantiated that Utro had violated building entry security procedures when he bypassed the security checkpoints in bringing the intern into EPA headquarters. We did not substantiate the allegation that Utro discussed classified information in violation of federal requirements. However, we did substantiate that EPA senior-level officials who were aware of multiple claims of unwelcome conduct by Utro, they did not take any actions against Utro as a result of receiving this information about him. Several senior officials were advised prior to or immediately following Utro's February 2014 selection as acting associate administrator for EPA's OHS that he had exhibited inappropriate behavior toward women. Our case was negatively impacted and delayed due to the fact that these senior officials did not notify us about their knowledge of other incidents of Utro's inappropriate behavior. This case revealed no criminal violations and was therefore investigated as a purely administrative matter. No criminal declaration was sought or received from the U.S. Attorney's Office. Utro retired from federal service in January of 2014. We will continue to work closely with the agency, our law enforcement partners, and Congress to ensure that allegations of employee misconduct are quickly and properly addressed. That concludes my prepared statements. Thank you, Mr. Chairman.
Thank you, Mr. Sullivan. We now recognize Mr. Myberg for 5 minutes.
Thank you very much, Mr. Chairman and Ranking Member Cummings and members of the committee. It's my pleasure to be here to testify today. I am Stan Myberg, the Acting Deputy Administrator of the Environmental Protection Agency, and I am accompanied here today by John Reeder, who is one of the agency's Deputy Chiefs of Staff, and again, I appreciate the opportunity to be here today. I have worked for EPA for over 36 years in 4 locations, starting here in Washington, in our offices in Research Triangle Park in North Carolina, and in our regional offices in Dallas and Atlanta. In both of those regional offices, I served as the Deputy Regional Administrator, which is the senior career office in that region. I held that position in EPA's Region 4 office in Atlanta for the last 18 years of my career until my retirement last year. To my surprise, last fall I received a phone call from EPA Administrator Gina McCarthy offering me the opportunity and the honor to return to the agency to serve as the Acting Deputy Administrator, a position that also serves as the Chief Operating Officer for the agency. That is the position I hold today. John Reeder, who is joining me today, is another longtime civil servant who serves as the Career Deputy Chief of Staff for EPA. John previously served overseas in the military from 1979 to 1981, and began his career in federal service as a presidential management intern in 1987. He has served in his current position as Deputy Chief of Staff since 2010. One of the reasons I came back to EPA was to again have the opportunity to work with the exceptional and hardworking people of this agency. I believe in the people of EPA. I believe in them because for over 36 years I was one of them. And I know how hard our 15,000 employees work day in and day out on behalf of the American people. EPA employees who engage in serious misconduct are not representative of the broader workforce. All of the EPA employees who work so hard, especially, deserve that we deal with misconduct or poor performance swiftly and with integrity and professionalism. And they further deserve our attention to their professional growth so that collectively we are able to keep our eyes on the mission of the agency. Since returning to EPA, I've had the pleasure of working with John and other senior agency leaders to increase our support of agency employees and managers with the goal of continued improvement of our workforce. In particular, we are working to improve our support for our first-line supervisors, develop a new and highly skilled next generation of senior leaders, and streamline our processes. First-line supervisors have some of the hardest jobs in any organization, and EPA is no exception. Our goal is to provide our first-line supervisors with the right tools and information to enable them in performing their essential role at the agency, including addressing poor performance or improper conduct early in those rare instances where it is necessary. Earlier this month, we launched a revised and updated First-Line Supervisors Toolkit, the first comprehensive updating of that resource in 15 years. Through the coming year, we will be convening focus groups of first-line supervisors to ensure we understand their needs and see how, as their senior leaders, we can meet them better. The agency has also placed a renewed emphasis on developing the next generation of senior leaders at the EPA. Earlier this spring, I announced the opening of EPA's first Senior Executive Service Candidate Development Program in many years. I am proud that EPA will enroll more than 20 candidates in the SES Candidate Program this year. In closing, EPA has an honorable 45-year history of protecting public health and the environment for the people of the United States. I am proud of the work accomplished every day by the employees of EPA and excited about our efforts to continue to improve and to better support our managers and staff across the agency. And with that, we look forward to any questions you may have.
Thank you, and I'll recognize myself for 5 minutes. Mr. Reeder, how long have you worked at the EPA?
Press that button.
Yes.
Mr. Chairman, 27 years.
So between the two of you, you've got about 60 years of experience at the EPA. We thank you for your service, but I don't understand with Mr. Peter Jutro, there were 13 times that women had reported matters to the EPA about some form of sexual misconduct, sexual harassment, and yet it took more than 13 times before you got serious about it. And then it finally percolated to the point where you were going to actually pursue it, and then he just retires. Because he was in his 70s, correct?
Mr. Chairman, I don't know his age.
Okay, he's roughly 70 years old, that is my understanding. But why does it take 13 times before you all get serious about it? That's what's so infuriating. Two of these incidents of the sexual misconduct happened at the White House. At the White House. So how does that, who wants to answer that question? Why does it take so long?
Mr. Chairman, I don't know where that comes from, and
The Inspector General.
Maybe the Inspector General is in a better position to answer the question about the incidences, because I believe many of those were discovered in their investigation and were not raised to management.
Mr. Elkins, Mr. Sullivan, my understanding is that 13 times these matters had been reported to EPA management.
Yes, it was reported to most cases to the victim's immediate supervisor. in most of the cases. Not every case. Some of the victims came forward during our investigation. But at least one of the incidents at the White House was reported immediately during the alleged sexual harassment and inappropriate conduct by Mr. Utro. The victim immediately communicated with her supervisor what Mr. Utro had done.
And that happened in 2009, 2010, something like that?
The last incident happened on or about July 29th, 2014.
But the one that was, one of the ones at the White House that was reported, at least according to what I've got written here, is back in 2009, 2010.
Yes, and then the second one happened in July of 2014.
I need you to help I don't understand why somebody has to ever tolerate this and then tolerate such mismanagement that you don't deal with it. That's the serious, I mean, these people are promoted. Go ahead, Mr. Reeder.
Thank you, Mr. Chairman. The way the sexual harassment policy works at the agency is if an employee complains about behavior, they would report that behavior to the supervisor. In most instances, those don't become formal cases, and the supervisor is obligated, and I hope they've done this, but the supervisor is obligated to take some action to either end the behavior or, if it's more serious, to conduct a more formal review and investigation. I cannot answer for the supervisors that may have been involved with Dr. Jutro over the course of his career. I'm going to
Okay,
yeah.
our time's limited here.
So
Under your policy, sexual harassment, first offense is either written reprimand or up to removal. Second offense is a 14-day suspension to removal. There was more than two of those. There were more than two of those, and that didn't happen. And on the third offense, 30-day suspension to removal. Why didn't you follow your own policy in this? This person ultimately got promoted.
I can't answer the question about what happened in those instances before he came to the Office of the Administrator. I'm sorry, Mr. Chairman.
Mr. Chairman, let me just speak to a couple of things. Since the incident that led to the Inspector General investigation occurred before I came back to the agency, I can't really speak to that. But I will say that the issues that were uncovered in the Inspector General investigation were a result of the agencies asking the Inspector General to do the investigation following the behaviors that occurred with the Smithsonian intern. And we appreciate.
But do you dispute the idea that 13 times women reported to somebody in management that this was a problem, and this person was getting promoted along the way? He got bonuses.
Where I was going with this was simply to thank the Inspector General.
Oh, well, that's not an answer. I don't want to thank the I want you to do your job. I want you to fire these people who are sexually harassing people at work. I want you to fire. I want you to live up to the obligation that you put out in your own manuals. That did not happen in this case. Do you dispute that?
What I don't dispute is that that kind of behavior was appalling and is intolerable.
You can say that, but then there's no consequence, and the guy gets promoted. It makes the situation worse. Would you disagree with that?
Mr. Chairman, again, in the specific case of Mr. Utro, the fact that the Inspector General was able to help in identifying things that had not otherwise come to light was useful, and I think contributed and backed up the swift action that was taken once we got
swift action?
Yes.
Where do you think you had swift action?
When the report came from the Smithsonian.
When's the first time a woman stepped up and said, "This guy's harassing me"? When was that time?
When the agency got the information from the Smithsonian intern, they acted immediately, contacted the Inspector General, took his badge, barred him from the building, and he never came back.
Mr. Sullivan, Mr. Elkins, to say that this suggests that they acted swiftly upon the first time, you shouldn't have to have the Inspector General go through this. Management should be able to deal with this immediately. And according to your own policy, that's what's supposed to happen. But that's not what's happening at the EPA. Mr. Elkins or Mr. Sullivan.
Yes, Mr. Chairman, it's my understanding of the facts that members of the Administrator's Office had noticed that Mr. Utro had some suspect conduct in the past. That information was was information that they had prior to Mr. Utro actually being assigned to have the acting position as the Associate Administrator of OHS. None of that information was provided to us prior to the incident with the intern. Mr. Sullivan may be able to give you a little bit more details.
Mr. Chairman, yes. On or about February 20th of 2014, when Mr. Utro was being vetted for the position, the then Deputy Administrator, Mr. Perciasepi, asked the acting Associate Deputy Administrator, Ms. Felt, to speak to Mr. Utro. During that discussion, Mr. Utro exhibited offensive behavior to Ms. Felt that she thought was completely inappropriate based on his comments. The next day, a senior executive who's a victim that we reported in our report of investigation reported to Ms. Felt with great specificity some of Mr. Utro's prior behavior. Ms. Felt told us she then took that information from the victim, who was a senior executive, and reported back to Mr. Perciasepi and other senior executives in the Office of the Administrator, urging them not to appoint him to the position of acting Associate Administrator.
And what happened?
Nothing. He was appointed. And they did some subsequent vetting, but we're not quite sure exactly what that vetting was.
My time is well expired. We now recognize the ranking member, Mr. Cummings.
Thank you very much, Mr. Chairman. I'd like to ask about why the EPA moved so quickly to remove some employees, but so slowly to remove others. And let's start with a case where the process seems to have worked quickly. Thomas Manning was a computer specialist in EPA's Chicago office who admitted viewing child porn on his work laptop. On March 14, 2013, IG agents interviewed Mr. Manning, and he signed a sworn statement admitting that he used his EPA computer to, and I quote, search the internet to view adult and child pornography. The EPA immediately put Mr. Manning on administrative leave, blocked his access to EPA servers, and banned him from the building. On April 10th, less than a month later, the EPA placed Mr. Manning on indefinite suspension without pay. On August 5th, the IG provided the EPA with a copy of the employee's sworn admission, and the agency then initiated termination proceedings. Today, Mr. Manning is currently serving a 30-month prison sentence. Mr. Sullivan, what is your view on how this case was handled by your office and the EPA, and was it handled quickly in your view?
It was handled very quickly and professionally by the EPA Region 5 staff. But one of the differences here, Mr. Cummings, is that Mr. Manning admitted to committing a felony. The child pornography, the viewing and possession of child pornography is a felony under federal statutes. So once he gave us his confession, confessing to a felony, we shared that with the Region 5 officials, and they put him on initially paid leave and then changed that to unpaid leave and then initiated removal proceedings, essentially because he had admitted to a felony, and the U.S. Attorney's Office had given us permission to share everything at that point with the Region 5 folks.
And I'm assuming he was aware that this admission could be used against him in a criminal proceeding.
Yes, and we also had permission from the U.S. Attorney's Office to use that confession or to provide it to the Region 5 folks in Chicago for them to use in their administrative action. So it was done a dual track simultaneously.
Okay, let's talk about the case that took much longer. On September 11th, 2013, the IG received a complaint that a GS-14 geologist had downloaded thousands of pornographic images. 1 week later, IG agents went to talk to this employee, and they personally saw him. This is amazing. Personally saw him viewing pornographic images on his work computer. I mean, so y'all just walked in on him? I mean, is that what happened?
That literally is what happened. The agent went over to interview him, walked to his workspace, and observed him in real time viewing pornographic images.
Wow. This employee signed a statement admitting that he surfed the internet for pornography, and I quote, as much as 5 to 6 hours per day, end of quote. So again, an employee was saying, I did it. He signed an admission. And in this case, however, the IG did not provide a copy of the sworn admission to EPA until June 19th, 2014. which was 9 months later. Inspector General Elkins, I'm trying to understand this. Why would it take 9 months to provide the employees signed statement to EPA?
Yeah, Representative Cummings, I think I'd like to defer to Mr. Sullivan, who has specific facts on that.
All right, that's very well.
Yes, sir.
Now, do we have a felony here?
No, there is
Okay.
no felony here per the viewing of adult pornography. The potential felony in the theory we were pursuing is that the geologist, we're not mentioning his name here, the geologist was committing a violation of 18 U.S.C. 641, the theft of government funds, because he certified on his time card that he worked 80 hours per week, but by his own confession, he worked significantly less than 80 hours a week, because between 2 and 4 or 6 hours a day he was viewing pornography. So the U.S. Attorney's Office initially accepted that theory and was preparing a criminal prosecution against the geologist. Therefore, we verbally briefed the agency, the supervisors, and the labor and employee relations attorney as to exactly what what the gentleman had admitted to. But we finally got permission from the U.S. Attorney's Office to physically turn over the confession, and we got specific permission from the U.S. Attorney's Office for the agency to pursue parallel administrative actions similar to what happened with Mr. Manning.
I see. Now, Mr. Myberg, even after the IG provided the sworn statement, it took another 9 months for the EPA to initiate removal proceedings. And why is that?
Well, Mr. Cummings, thank you. Let me just state the obvious, that viewing pornography has no place at EPA.
I got that. Now, answer my question.
Right. In the case of the Chicago instance that you mentioned, there was, in fact, a reasonable cause to believe that the employee committed a crime for which a sentence of imprisonment could be imposed, and that gave us the ability in that case to act as Mr. Sullivan has described and have that employee immediately suspended without pay. In the case of the employees otherwise, we were waiting for a declination of prosecution from the U.S. Attorney's Office because we do not want to interfere with the prosecution of an investigation or of a crime or of any other activity.
Did the U.S. Attorney ask you for that?
We asked to make sure we knew when that was the case so we could then proceed.
Did you? Well, you didn't. No. You didn't answer my question. Did the U.S. Attorney tell you what you just said? Did they tell your folks at EPA?
I do not know the answer to that question.
Do you know whether whether there's a document that says that you may have in your possession?
I don't know. I don't know the specifics of that case enough to say. I do know that it is our general practice to not try to pursue an administrative action.
Yeah, but wait a minute now. Mr. Sullivan, do you know anything about this piece? I mean, you drop out of it? You would have dropped out of it by now?
No, sir.
Okay, well, tell me, do you know about the
Yes.
U.S. Attorney requesting asking not to, the department not to proceed for a while? Do you know anything
No,
about
it is
that?
just the opposite. We received specific permission from the U.S. Attorney's Office for the EPA Administrator's Office and the powers to be to pursue parallel administrative
That's
action.
what I thought you said.
Yes, sir. That's correct.
I thought maybe I missed something.
No. And
Now, Mr. Marbury, did you hear that? I'm sorry, Mr. Sullivan, what were you saying?
Yes, and we communicated that to the geologist supervisor and to the labor and employee relation attorneys at EPA.
So in other words, EPA knew that they could proceed, right?
Yes, sir. Yes, sir.
And you're saying almost, I'm not putting words in your mouth, but you're saying almost the opposite of what Mr. Myberg just said, I think. Yeah, you need to.
Mr. Cummings,
yeah.
yes. Now, I think what there is here, and one of the lessons from these cases that I completely agree with, is that there is a need for a better understanding and communication between the Inspector General's office, the Department of Justice, and our own labor and employee relations people to make sure everyone knows the terms of engagement. I think people were acting in good faith, believing that they did not want to interfere with the potential criminal prosecution. But as Mr. Sullivan has said, the Inspector General's office...
Let me give you some advice.
Yeah.
In the future, maybe you need to just, if the department is confused, maybe they may want to just pick up the phone, dial some numbers, and call Mr. Sullivan. If they want to know where they stand, You wouldn't mind taking that call, would you?
Mr. Cummings, not only would we not mind it, but in the case of the geologist and the other gentleman who was the environmental specialist, we had continual collaborative interaction with the agency, the supervisors, and the labor and employee relations. We had contact with them on a weekly basis and multiple times every month during this period of action.
Just the last question. If an employee admits to misconduct and if he signs a sworn statement detailing what he did wrong, we should be able to share that information immediately. Mr. Meyerberg, is there any reason, I want you to listen to this too, Ms. Sullivan-Selkins, reason the IG and the EPA could not adopt a policy today, not yesterday, today, providing that sworn statements like these will be turned over to the agency as soon as possible? Is there anything preventing us from doing that?
Well, the only thing that would prevent us is that once the case is accepted for prosecution, we would have to get the acquiescence of the U.S. Attorney's Office before we turned over that document. But I can't imagine that any U.S. attorney would say we can't turn over the confession to the agency for them to take administrative action.
Mr. Meyerberg?
I think that's something we would welcome, and we welcome working with the IG and the Department of Justice.
You all have, I would appreciate it, and I would thank you, Mr. Chairman, for your courtesy. I really think that if there's a way that you all can work that out, that would be very helpful. Not every single thing has to be legislated, I don't think, but you all should be able to work this out. And would you, I'll talk to the chairman, and you all can bring us back some type of proposal or something so we can move on this, okay? Because at the rate we're going, we'll be talking about the same stuff, some of us, if we're still here, 10 years from now. All right? Thank you, Mr. Chairman.
I thank the gentleman. The chair recognizes the gentleman from Michigan, Mr. Wahlberg.
Thank you, Mr. Chairman. And I think, you know, as I'm listening to this testimony, listening to this, well, we've heard it before, it appears that there may be some need for the taxpayers to be protected from the environment of the EPA. It's a concern that has to be addressed. Mr. Elkins, yesterday you indicated, I believe it was around 5:28 after business hours, you received an email from Administrator McCarthy stating that the EPA had rescinded the MOU between the agency and the FBI. Mr. Elkins, where does Administrator McCarthy's action leave the EPA OIG? What are the next steps?
Thanks for that question. Actually, it leaves the whole situation muddier than it was before. In effect, what the administrator has done, well, first of all, let me start out by saying that my office has never really had an objection to an MOU with the FBI and the EPA on how to move forward. That would create a clear path that everybody understands who's on first, who's on second.
But you're all part of the game then.
We're all part of the game. However, though, we wanted to be a part of that discussion. That never happened. We were never a part of the discussion. So in effect now what we have is that by the administrator doing away with the MOU, and if you read the plain language of her email, it pretty much puts everything back to square one, where the Office of Homeland Security will continue to do investigative activities with the FBI, and will decide when they're going to bring the EPA OIG into, into an investigation. This is untenable. It's dangerous. And at this stage of the game, we're still in a fog.
Which leaves a crucial ally tool out of the process for people like us as well.
Yes.
Representing the taxpayer.
Yes, and to the extent that the FBI has always said to the administrator, just let us know who the point of contact is going to be at the EPA so we can work with them. What this does is take away that point. So the FBI doesn't know. I mean, basically, the point of contact is back to the Office of Homeland Security, which in the past has excluded my office from participating. So it's a serious issue.
The hen house is not guarded. Mr. Sullivan, were senior level EPA officials such as Mr. Reeder cooperative in volunteering information to the OIG in order to assist you in uncovering further information about Mr. Utro's past inappropriate behavior? And probably more importantly, how many times did you have to interview Mr. Reeder in order to obtain the information you needed to proceed with your investigation?
We had to interview Mr. Reeder 3 times, and there was a series of different subjects we discussed with him. And then with each interview, When we had obtained additional information, we then asked them additional questions. So eventually we got more information from Mr. Reeder. But the first interview was rather limited, and we subsequently found out that, I don't know whether it was our fault for not asking the right questions, but we subsequently found out that Mr. Reeder had additional information which he had during the time of the first interview, but ultimately wasn't given to us until after the third interview.
Mr. Reeder, why didn't you give it to them? You had the information.
Congressman, I'm not sure what particular information Mr. Sullivan is talking about. So if you were to make it more specific, I'm happy to cooperate and answer the question.
Well, if you're listening to the first question, it took a series of interviews to get the information that you should have had. And at least Mr. Sullivan had indication that you had it, but there was not a forthcoming in trying to get to the bottom of bad behavior.
So I'll try to be helpful in clarifying that. I believe Mr. Sullivan's referring to something that another employee, Lisa Felt, had told me prior to the placement of Mr. Utro in the position. And if that's what he's referring to,
Mr. Sullivan?
I can certainly address that question.
Is that what we're referring to?
Yes, Mr. Wahlberg. Ms. Felt, we found out subsequent to Mr. Reeder's first interview that Ms. Felt told us specifically she discussed her concerns about Mr. Utro with Mr. Reeder and other senior executives, and during our first interview, Mr. Reeder never told us that.
Okay.
Yes.
So, my concern as I listen to this is that we have employees who receive pay while on administrative leave for long periods of time. We have people who can retire to get away from some of the impact of their efforts. Mr. Elkins, would you be in favor of legislative or other fixes that would streamline the process by which federal employees could be terminated, could be prosecuted, would have their administrative leave shortened, and the impact to the taxpayer impacted in a positive way? And I say this, having introduced legislation on SAS streamlining to get at these issues last term. That legislation is upgraded, and shortly, in the next couple of weeks, will be introduced as well. But would that be of help to you?
Well, let me answer the question this way. I believe that justice delayed is justice denied. And whether it's a criminal case or an administrative case, employees need quick action to determine whether or not there's guilt into misconduct. So any legislation that sets some sort of timeline, like a speedy trial type of an instance that requires agencies to move quickly, efficiently and with a sense of urgency, I think would help the agency and the employee.
Thank you.
I thank the gentleman from Michigan. The chair recognizes the gentleman from Massachusetts, Mr. Lynch.
Thank you, Mr. Chairman. I want to thank the witnesses for your attendance. Under the Inspector General's Act, and I actually think if we're going to look at new legislation, and I think we need to, we look at the authorizing statute for Inspectors General, because this side deal between the FBI and the EPA to shut out the Inspector General is problematic. It basically takes Congress out, as the gentleman previously indicated. It takes Congress out. There's nobody representing the taxpayer, and obviously nobody protecting the employees either, the ones that were harassed. Mr. Elkins and Mr. Sullivan, thank you so much for your service. You're both frequent flyers to this committee, and we appreciate your great work. One of the provisions in the Inspector General statute says that when probable cause becomes apparent, that you automatically have the authority to subpoena when there's probable cause that a crime has been committed. Now, certainly, either when the 10th woman or the 11th woman or the 12th woman complained about Mr. Yutro, I think you probably have probable cause to intervene and to subpoena the records that the EPA is withholding from you. Certainly when you get a written admission of guilt that the person is actually viewing pornography, for numerous hours during the course of the day, when you have a stipulation that they are, violating federal anti-pornography statutes, certainly when you have an admission, a stipulation from the defendant that they have violated the law, that is probable cause. So, what was the problem with once you had the admission of going forward? It would seem that this delay for additional evidence after the individual stipulated that they committed the crime, that they are guilty, and then there's a 9-month dialogue or a 10-month dialogue about additional evidence. You don't need, once the defendant admits, stipulates that they have committed the crime, you don't need any more evidence to take action. That's a stipulation, and you can go ahead, you can go forward. Am I missing something?
No, sir. Let me try to put this into a little bit of a perspective. On the subpoena issue, Inspector Generals, yes, we do have subpoena authority, but we cannot use a subpoena against federal employees or federal agencies. It doesn't work that way.
If the statute says you do.
Well, we do.
As a matter of fact, that's the only thing you can do is subpoena the agency that you are charged to oversee.
No,
that's the way the statute's written.
No, the statute is not subpoena. We can't use subpoenas against federal employees. We can use subpoenas, yes, but not against federal employees. To the extent that there's an administrative process going on, that's one issue. If it's a criminal matter where the U.S. Attorney is involved in, then the U.S. Attorney, through the U.S. Attorney's office, we can use subpoenas. But that's what the IG Act provides.
It says in the statute that authorizes you, Title V, subsection 6, that you have the right to unfettered access to all materials.
I do.
It also says that you can exercise and issue a subpoena.
Yes.
To gain those materials.
Two different things.
Okay, so
yes, we do have unfettered access.
It doesn't sound like you have unfettered access.
No, we don't.
Well, you're telling me we have unfettered access, and I said it doesn't sound like you have unfettered access, and then you say we don't have unfettered access. No. What? I'm really, I'm at wit's end here because nothing's happening.
Well, sir, let me see if I can answer your question more directly.
Please.
Because this is not really confusing. The statute provides that we do have unfettered access, that the agency needs to cooperate with us. That's separate from subpoena issues.
That's the definition of unfettered.
But the agency, in order for that to work, the agency has to cooperate with us. We do not have that cooperation.
Right.
If we don't get the cooperation, it doesn't work. I can't issue a subpoena to compel that cooperation. That's the distinction.
Okay, so we need to change the statute. We need to change the statute.
That would be
not only that, we need to, in my opinion, we need to put a provision in here that there's an obstruction of justice penalty against individuals who get in the way of justice, of prosecuting these cases, because it's not merely an absence of reporting. There's an active effort here, in my opinion, to protect these employees. When you have an admission from an employee that they have broken the law and you promote them, or if you have an admission within your department from an employee that works for you that they're downloading porn 4 or 5 hours a day, and you just kick the can down the road and let them retire without penalty, that's complicity. That is complicit in allowing that person to break the law and escape justice. And I'm just beside myself with what's going on here. It's absolutely pathetic. And I know there are a lot of good employees over at the EPA, and this is just a disgrace to them. We're painting them with this brush, and you're not helping. I'll yield back.
I thank the gentleman. The chair recognizes the gentleman from South Carolina, Mr. Gowdy.
Thank you, Mr. Chairman. Mr. Chairman, you've been on this committee for a number of years now, as have I, and it's the same damn song, it's just a different verse. We can't investigate because there's an ongoing Inspector General investigation. We can't investigate because there may possibly be pending criminal charges. And then we hear, Mr. Chairman, last week that we can't discipline employees for anything other than sexual harassment. And here we have a fact pattern that includes sexual harassment and nobody's being disciplined. Mr. Sullivan, what's the total number of women who made allegations against Mr. Jutro?
17.
17 and give me some of the specific allegations.
Well, some of them are pretty graphic, and I don't know if we want to discuss it.
Oh, yes, I do, because the two men beside you either knew about them or should have known about them and didn't do a damn thing about it. So the more graphic, the better.
Well, on one occasion, which was in December of 2013, Mr. Utro was at a restaurant in the Wilson Plaza right next to the EPA headquarters with one of the senior female employees. And she described to Mr. Utro that she had to leave to take the train home. And he perked up and said, "Train? I've never had one of those." And she knew exactly what he meant.
Oh, I think most of us know what he meant.
Yes, and she was very offended by that statement.
As well she should have been. What else?
At the incident at the White House in July, a female colleague was at the White House on an assignment with Mr. Utro, and Mr. Utro asked her what she was doing, and she said, "I am tweeting back the event here so our colleagues back at EPA headquarters can understand what's going on and can follow in real time." And he said, "Oh, twatting, I really like twatting." Again, referring to part of the female anatomy.
Mr. Reeder, were you aware of an allegation of inappropriate and unwanted sexual discussion at an EPA happy hour on December the 4th, 2013 at a restaurant? Were you aware of that? You know why you weren't aware of that?
Sorry. No, sir.
You know why you weren't aware of that, Mr. Reeder?
I don't know why.
Because you didn't bother to ask Mr. Jutro's supervisor when you during his background check. He knew about it, but you didn't bother to ask him. How about on July 29th, the same female was again the victim of inappropriate and unwanted sexual discussion by Mr. Jutro at the White House Innovation for Disaster Response and Recovery Day. Do you know about that?
I do not know.
You know why you didn't know about that, Mr. Reeder?
No, sir.
Because you didn't bother to ask the person who did know, which was the immediate supervisor of Mr. Jutro, while you were vetting him for another position. Did you know about an inappropriate and unwanted hugging and kissing that began with one of the victims in 2007?
No, sir.
You know why you didn't know about that, Mr. Reeder?
It wasn't told to me.
Because you didn't bother to, no. You weren't told, you didn't ask. You didn't interview his immediate supervisor. And do you recall what your rationale was for not interviewing that immediate supervisor?
Yes, sir.
What was that?
At some point before Dr. Jutro was put into the position,
I'm looking for an answer. I'm not looking for an encyclopedia. What reason did you give for not interviewing the immediate supervisor of the person that we're describing?
Congressman.
You want me to refresh your recollection, Mr. Reeder?
I think if the
Because you don't talk to people at that level. That was your response.
That's the characterization of somebody else, sir. That's not my characterization.
It's the characterization of the Inspector General, Mr. Reeder.
So if you would like, I can explain.
Well, no, I'm
the
going to get
process.
through first, Mr. Reeder.
Yes, sir.
Were you aware of an allegation of inappropriate and unwanted hugging and kissing that occurred at another White House meeting in approximately 2009, 2010?
No, sir.
Do you know why you weren't aware of that, Mr. Reeder?
No, sir.
Because you didn't bother to ask the person that had knowledge, which would have been the immediate supervisor of the person you were vetting for another office. Were you aware of inappropriate and unwanted hugging and kissing and sexual discussion that began with yet another victim in 2002?
No, sir.
You know why you weren't aware of that, Mr. Reeder?
Congressman.
Because you didn't bother to ask the person who knew. Did you volunteer the information when you were asked?
I'm sorry, I'm not sure what information you're referring to.
Did you know any of these allegations, Mr. Reeder?
No, sir.
Why did you not interview? Well, let me ask the Inspector General. Do you agree with that, Mr. Inspector General, that Mr. Reeder was not aware of any allegations of wrongdoing at the time that you interviewed him and failed to volunteer it?
Let me defer to Mr. Sullivan, who has the facts on the investigative piece.
Mr. Garrity, we determined that at a minimum, Mr. Reeder was aware of the offensive discussion that Mr. Utro had with Ms. Felt, and he was also aware of the reporting of Mr. Utro's sexual harassment, including unwanted hugging and kissing with a senior executive, and Ms. Felt reported that to Mr. Reeder as well as other senior people, including the former Deputy Administrator, Mr. Perciasepe, before Mr. Utro was appointed as the Acting Associate Administrator.
And what did Mr. Reeder do with that information?
I don't know what he did, but we didn't find out about it.
But he was on notice before the promotion was made of some of these allegations.
Yes, that is.
And would have been on notice of more had he bothered to ask the immediate supervisor.
Well, had he asked the immediate supervisor, we had interviewed the immediate supervisor. That supervisor told us I would have absolutely shared that with Mr. Reeder, but he was never contacted.
I yield back, Mr. Chairman.
I thank the gentleman from South Carolina, Mr. Reeder. I'm concerned that as a chief of staff, you're charged with a particular duty and a particular task, and yet under questioning from Mr. Gowdy, it sounds like that you didn't even conduct a thorough investigation before making a recommendation on this individual.
Mr. Chairman, I disagree with that.
Well, how could you disagree with all the questions that Mr. Gowdy has just posed to you, and you had no knowledge, but yet Mr. Sullivan was able to get that by picking up a phone call and having a discussion with it? How could you disagree with that?
So,
in hindsight,
would
you would acknowledge that you were wrong, would you not, in hindsight?
in hindsight, I would have asked a different question. Yes, sir.
All right. Well, the chair recognizes the gentlewoman from New York, Miss Maloney, for 5 minutes.
I'm just astounded, and I'm getting a little clarification. It appears that you sexually harass someone, and you might just get a promotion. You're not disciplined. You're not put on leave to protect other employees from inappropriate behavior. It appears you get a promotion. And I want to follow up with really the questioning of my colleague from the great state of South Carolina, and follow up with you, Mr. Reeder. The IG report indicates that you were one of 4 senior officials who was notified of the concerns of 2 female employees on about February 20th. Is that correct? Were you notified by these female employees of their concern?
I had a conversation with Lisa Felt, who told me of something she had heard from a third party, yes.
And did you follow up and talk to the third party?
No, ma'am. I had the understanding from Ms. Felt that the third party was not interested in speaking about the matter further.
Did you conduct any further checks of Mr. Utro after you were informed of these concerns? You know, sexual harassment is a crime.
Congresswoman, in this instance, Ms. Felt told me that there was an issue, that there was some behavior which was not described to me. So I think it's important for the committee to know what I did know and didn't know. I did not know the place, the date, the time, the description of the activity or behavior. I didn't have a complainant, and I didn't have a witness. I had a concern about something that he had done inappropriately at some point in the past. It certainly wasn't enough for me to open an investigation, and I was frankly conflicted about what I could do with that kind of information. It was a very difficult set of facts for me to deal with, frankly, to act on.
Well, isn't sexual harassment an inappropriate touching and inappropriate language towards your coworkers defined as sexual harassment? You may not think it's inappropriate, but certainly my colleague on the other side of the aisle did, and I want to follow up on when you're going to promote someone, you talk to the people who worked with them. An allegation is an allegation. If they're serious, I try to follow up on them. I got one the other day. I'm making some phone calls on it. But why didn't you check with the supervisor? The supervisor would know whether or not this person should be promoted. And why didn't you check with Mr. Juto's immediate supervisor? And is it true that you didn't check with the Office of Research and Development or the supervisor in his case or whatever? Why didn't you check with him?
Congresswoman, when I heard this incident, which, as I described, was very vague information about some inappropriate behavior, I did make additional calls. to people that I believe would be in a position to know more about Dr. Jutro.
Well, wouldn't his immediate supervisor be in a better position than whomever you decided to randomly call? Why didn't you call him? I'm just curious. What were you thinking?
So I called the senior people in the Office of Research and Development. I did not call Mr. Sales. In the normal course of discussing a temporary detail of this matter, I would talk with somebody who's in charge of the SES folks in the other office, in this case, Research and Development.
But Mr. Sales was his immediate supervisor, correct?
Correct, and I have to tell you that if I really believe, and I understand now that this maybe didn't happen, I don't know, but I really believe that if there were serious concerns about Dr. Jutro's behavior, those were people that would know. This was the person in charge of HR and management.
I think supervisors, people that are close, you know, hindsight is, 20/20, but knowing what you know now, do you believe it would have been good judgment and appropriate to check with his supervisor?
Knowing that what I know now, I think I would have called the same people, and I would have been explicit in whether they had checked with the supervisor of the individual. I would have been explicit.
But you would not have called the supervisor.
I may or may not. If I had belief that something needed further investigation, I certainly would. But in the course of a normal vetting, I would be explicit that they checked with the supervisor.
So you regret your actions now?
I don't know what the supervisor would have said, Congresswoman. I certainly wish that we had that information at the start.
Well, I think the gentlewoman, Ms. Reeder, I find it just mind-boggling that you can't even say that in retrospect that you made a mistake. I mean, it's very ironic where an agency is charged with making sure that we have a clean environment, but yet has a work environment that's polluted. It's just beyond comprehension. And Ms. Maloney makes a good point. So you can't even, in retrospect, say that you made a mistake.
Mr. Chairman, I honestly believe I did the best I could with the information I had. I do wish I had spoken to the, yes, I do.
Well, Mr. Reeder, I would suggest that you are probably the only person that believed that you did as much as you should have done. And with that, I'll recognize the gentleman from Alabama, Mr. Palmer.
Thank you, Mr. Chairman. I thank the witnesses. I've been sitting here listening to the testimony, and frankly, I am absolutely astonished that either of you still have a job. It is absolutely unbelievable. Not only have you allowed a culture of sexual abuse to exist in your agency, you sit here and deny that you allowed it. You know, there was a report from Senator Jeff Flake last year that pointed out that there were 8 people on administrative leave at the EPA, apparently because they were involved in cases of alleged serious misconduct, and they were paid $1,096,000. One person was on leave for 3 years. Were any of those people involved in sexual misconduct? It says yes or no. Mr. Meinberg, Mr. Reeder, either one of you, yes or no?
Congressman, let me speak to.
No, it's a yes or no.
No, the question that you asked first was about a cultural sexual harassment, which I.
No, that wasn't a question,
agree
sir.
with.
That was an affirmative statement. You know, the EPA tries to regulate everything from greenhouse gases to ditch water to cattle flatulence. But if someone makes the slightest mistake in their business or farm, their duties as a municipal officer, they are immediately descended upon by the EPA. They're subject to heavy-handed action. There have even been cases where the EPA has showed up with weapons drawn. Last year, you backed off trying to garnish wages. You've taken personal property. People face massive fines that have cost them their businesses, their farms, their careers, their savings. Yet you have employees who have been sexually abusive of women and others engaging in activities that are sexually abusive of children, and no one was fired. They were put on administrative leave, paid administrative leave. The EPA, in some cases, have cost private citizens millions of dollars, virtually destroying their reputations and their lives, and at the same time, you have protected sexual perverts, even rewarded them with promotions and pay increases. Mr. Meinberg, Mr. Reeder, the EPA has not only mismanaged it, is misguided, and in these cases, apparently morally corrupt. How can you sit there and defend these actions?
Congressman, with respect, there are several elements to your question, some of which go far beyond the scope of this hearing.
I haven't asked a question. I've made an observation. My question is how can you defend these actions? You have not given a definitive defense of any of this. The gentleman from South Carolina, the gentlelady from New York, you have yet to give a definitive defense of your actions.
Congressman, let me, again, sort through a couple of different aspects of this. One is we are very clear at EPA that sexual harassment, that viewing porn is not a part of EPA.
Why would you go after honest people who are trying to run a business, trying to raise a family, run a farm, who make a mistake in a violation and come down on them, in some cases with fines of $32,500 per day? When you have activities like this going on within your agency and you can't act on that as definitively and as decisively as you do people who are trying to run a business or run a farm.
Congressman, with respect, that's not an either-or question. We, in fact, do many actions, and anyone who is subject to an enforcement action by EPA is entitled to due process under the law. And we
I wouldn't be at all, I wouldn't have any problem at all with due process for people who are actually charged with something. You impeded the investigation of the Inspector General. You withheld documents. In my opinion, you obstructed justice. I don't see how you can defend it. Mr. Chairman, I yield the balance of my time.
I thank the gentleman from Alabama. The chair recognizes the gentlewoman from Michigan, Ms. Lawrence.
Good afternoon, or good morning still. I have some questions for the witnesses who are here today. You have been members of the federal government for a while. So my question to Mr. Sullivan, have you ever received EEO training as a manager?
Yes, ma'am.
How often do you receive it?
Yearly.
Okay. I want to ask Mr. Meinberg, have you received EEO training as a manager, and how often do you receive it?
Yes, indeed, I have annually as well.
So, Mr. Reeder, the same question to you. Can you tell me how many years you've had in federal government, and have you received the training?
Yes, I have 30 years combined military and federal service, and I have received the training.
Okay. In this training, is it stressed upon you that your obligation to address any complaint of alleged sexual harassment or a hostile work environment?
I think I can answer that. The policy calls, actually it advises employees to tell their supervisor, and the supervisor is obligated to take action, which could be informal or formal, depending on the seriousness of the complaint.
In your training that you received, do you feel that the allegations and the proper action that should have taken was processed the way you've been trained?
I honestly don't know of the cases prior to the time that Dr. Jutro was in my office.
No, I'm talking about where you were directly involved.
Yes.
You felt you met the training and
Yes,
the obligation that you had as a manager.
Yes, ma'am.
So I clearly I've stated before I was an EEO investigator. So I clearly I clearly see a disconnect from the training, the responsibility you have as a manager, and what happened to an employee. When you have 17 women, 17, who are giving you the reports that their work environment is one that has been compromised because of sexual harassment, as a manager, part of your responsibility is to manage your supervisors. You cannot divorce yourself from what happened.
Absolutely.
It is challenging for me to sit here and know that women who come to work to earn a living, to take care of their families, women or men, in our federal government, who are the gatekeepers, the EEOC, with federal agencies to take care of the work environment. You failed. Because if these 17 women who, over the course of the years, and you can't divorce yourself from it because it was a supervisor. I do have a question for you. How would you change the environment that we have seen here? You've been trained, you've been a manager for 30-plus years. And this goes to Mr. Sullivan as well.
I'd be pleased to answer that. When we have allegations that are filed with the Office of Civil Rights, those are tracked, and we have pretty good data if it's an EEO-related type of harassment. In fact, last year we had one filed case of sexual harassment with our Office of Civil Rights. In the preceding year, we had two. Very low in number, but nonetheless, those three cases were filed with the Office of Civil Rights. There were other cases that were
You do know if there is an environment where you feel that you're not going to be heard and there's consequences, filing of the formal complaints does not negate your responsibility for a work environment. Do you know that?
I'm getting there. I think what might be helpful for us is to have a better system of knowing what other cases that are not going to the Office of Civil Rights, how they're being handled, and how many there are. And so right now, the way it's handled, they're not all necessarily centrally identified. Individual managers may have dealt with a case informally and may have counseled the person, and once the harassing behavior stops, that's usually the remedy that the victim wants. They want the behavior to stop. Once it stops, that sort of is the end of that record, and we don't really have a good sense of how often it's happening across the agency.
Mr. Sullivan, what are we doing to ensure that people come to work and they're not in this environment where it seems to be kind of, well, if they stop, it's okay, that we've achieved the goal. They didn't file a formal complaint. What is your response to that?
Mr. Sullivan, the gentlewoman's time has expired, but you can answer the question.
Thank you.
Thank you, Mr. Chairman. Well, Ms. Lawrence, we in the Inspector General's office do not normally investigate EEO violations. There's a separate process within most agencies. The IGs don't normally.
But you have the responsibility.
Yes, ma'am. I will answer that. So in this case, we did a very thorough and professional investigation, and some of the victims, quite frankly, told us they were afraid to report some of this misconduct to their supervisors.
Absolutely, it happens every day. Because you don't have managers who take it seriously and respond.
That's correct. So there were some of the victims that were afraid to report it, and then when they were interviewed by my special agents, they opened up and told us exactly what happened. And there were other victims that felt that Mr. Utro had absolutely was not held accountable at all for his actions.
Okay, we'll follow up. If you can follow up in writing. The chair will recognize the gentleman from Tennessee, Mr. Duncan.
Well, Mr. Chairman, thank you very much, and I'll say to Chairman Chaffetz, I appreciate him calling this hearing and staying on top of these matters. I'm in my 27th year in Congress. In that time, I've served on 4 different committees, and I've been in so many hearings about horrendous waste by federal departments and our agencies. very stupid decisions by federal departments and agencies. I've heard about these on the floor of the House from every committee. I've read about these dumb decisions and horrendous waste and all kinds of articles. But this committee is the main investigatory committee of the Congress. In the time I've served on it, we've investigated, I guess, almost every department and agency at some point or another. And we realize when we sit here that we just see the tip of the iceberg because we're not in these departments or agencies full time. So we're not seeing all the misconduct, all the waste that's going on. We're just seeing a tiny little portion of it. But I have to tell you, Mr. Myberg and Mr. Reeder, that what I've heard over these last few months about the EPA is absolutely the worst I've heard of any department or agency in the entire federal government. A few months ago, we were in here and we hear about this Mr. Beal or Dr. Beal, who pretended to be a secret agent for a number of years and drew, I think, almost $2 million in salary at the time that he was doing no work. He was taking vacations around the world, just spending most of his time at home doing nothing except just, then now we hear about EPA employees who are spending hours of their workday looking at pornography. And then we hear about another high-ranking EPA employee who's got 17 women charging him with sexual harassment, and it just goes on and on and on. And it seems to me that the people who are running the EPA, and both of you gentlemen are very high-level EPA employees, the people who are running the EPA should be ashamed. You should be embarrassed. And it appears that the EPA has too many employees and not who are not doing anything, and then the ones who are doing work seem to be running amok, going almost power mad, and it's just gotten ridiculous. And then I'm concerned about another thing. District Judge Lamberth made a ruling not long ago, and he said in the case of the Landmark Legal Foundation versus EPA that the EPA did not comply with FOIA requests, that they were extremely negligent in processing the request and apparently were delaying things to help the presidential election in 2012. And then we have another instance of the NFIB, the National Federation of Independent Business, sending a FOIA request to the EPA in May and not receiving an answer until December 30th. And the abuse just goes on and on and on, and then these people are allowed to keep these high-paying jobs, very high-paying jobs, way above what average Americans are making. They keep these high-paying jobs for months or even years after they've been discovered in doing some of these terrible, even sometimes criminal activities. It just is a shameful, embarrassing, pitiful record. And everybody connected with the EPA should be ashamed and embarrassed about this because, as I say, we know we're just getting the tip of the iceberg. Mr. Elkins, do you think and in fact, this man, Mr. Utro or Dr. Utro, was allowed to move his retirement date up so that he wouldn't be accessible to your people? At least is that correct?
Well, the facts suggest, sir, that he didn't want to talk to us, and he used the vehicle of retirement to effect that outcome.
Do you think the EPA has been moving fast enough on these administrative procedures? It looks to me like they've been dragging their feet, as I think Mr. Lynch said a few minutes ago, trying to protect these employees, I guess because some of them were friends.
Well, sir, I can't speak to the motives of the EPA.
Right, I understand
management. On the other hand, we've done everything that we can do on our end to make sure that we follow the facts and bring the facts to the EPA as soon as possible so they can act.
Well, I want to say this. We certainly appreciate the work of your office because a lot of these terrible activities wouldn't be here in front of us if it wasn't for your staff in your office. And so I just want to say that I appreciate that, and I hope that we greatly decrease the funding of the EPA and greatly decrease the number of employees so that the people over there won't have all that time on their hands. And so maybe they'll do some good things for the country instead of doing so many ridiculous, shameful, wasteful things. Thank you very much, Mr. Chairman.
I thank the gentleman from Tennessee. The chair recognizes the chairman of the full committee, the Honorable Mr. Chaffetz from Utah.
Thank you. I do appreciate it. Mr. Myberg, what viewing pornography at work, is that allowable or not allowable?
That is not allowable by very explicit EPA policy.
And what is the penalty for viewing pornography at work?
The penalty will depend on exactly what happens, on what the extent.
So what's the range?
The range is from a warning to dismissal.
Now, you say in your testimony, page 2, all the EPA employees who work so hard especially deserve that we deal with the misconduct or poor performance swiftly and with integrity and professionalism. Do you think you've lived up to that standard?
I think that we are moving as swiftly when we get information. I think there is room for improvement, and we've discussed that already this morning in the communication between ourselves, the U.S. Attorney's Office, and the Inspector General.
Listen, I appreciate that, but the cases we talked to you about, which are some of the most egregious we've ever seen in federal government, there is no evidence that you have moved swiftly. I don't see any evidence of that. Let's go back to Mr. Manning for a second. Why didn't you swiftly and immediately, you put him on paid administrative leave?
No, sir. I believe Mr. Manning was the case in Region 5 where he had child pornography. And
yes.
He was immediately taken on unpaid leave because there was a there was reasonable cause to believe that he had committed a crime for which a sentence of imprisonment could be imposed.
My understanding is he was put on paid leave and then transitioned to unpaid leave. Mr. Sullivan?
Yes, Mr. Chairman. He was initially put on paid leave for about 3 weeks. Then the agency transitioned that to unpaid status.
Let me ask you, Mr. Elkins. Last night, my understanding is the EPA administrator sent out an email rescinding the MOU with the FBI. Explain that to us, and what is it that you're not getting that you believe you should be getting?
Thanks for that question. Yes, I did receive just around 5:30 last night an email from the administrator that stated that she had decided to rescind the MOU. What that really does is murky up the waters. We have never said that the OIG did not want an understanding or an agreement with the agency and the FBI so that we all understand what our roles are. You have to understand, sir, that we are in an environment where we have agents who are armed, who may find themselves in situations, if they don't know what they're doing, you can have a blue-on-blue sort of situation. It's a very dangerous situation. What the administrator's memo basically has done is that now we really don't have any guidelines. What we have is that OHS now will make the determination and work with the FBI on any intelligence matters to come in. It seems that whether or not they're criminal misconduct, we don't know, and the OIG is then dependent on the OHS informing us as to what's going on. I've been having this discussion for 5 years. That's been the practice. It's never worked, even with the MOU, and now since the MOU has gone away, what gives me any assurance that things are going to be any different? So we are back to square one again in a murky situation, and so that's the problem that we have. The OHS has investigators. That office is growing. They even have more investigators now with guns and badges. So the situation is actually getting worse rather than better.
So how should it be? What should, from your opinion, you've been around the block for a long time, how should it be?
Well, what should happen is a clear acknowledgement of the OIG's primary role in serving as the investigative arm of the agency where employee misconduct is involved. Irrespective of whether it's an intelligence issue or whatever the matter is, the OIG should be the point of contact. That message needs to come clearly from the administrator so that everybody understands what their roles are. That has not happened.
Mr. Myberg, what's unreasonable about that?
Mr. Chairman, a couple of things. One is, I have to admit I'm a little puzzled about the rescinding of the MOU, because it was my understanding, and we'll have to work with the OIG on this as we move forward, that the MOU itself was an objectionable thing, and that the rescinding of the MOU was something that was desired, and I think the administrator's intent was to take that issue off the table. Now, the Inspector General's office has its jobs, and the OHS has its jobs, and we fully agree with the Inspector General that the Inspector General needs unfettered access in the conduct of his lawful duties, and the administrator has stated repeatedly that that is what she expects of every EPA employee.
Do you have unfettered access?
No, sir, we do not have unfettered access.
Mr. Myberg, why doesn't he have unfettered access? You just said he should.
I admit to being puzzled, because from where I sit, at least, he does.
Okay, Mr. Elkins, what do you not have unfettered access to?
Well, as I previously stated, sir, in terms of investigations, we conduct the investigations. We have the ultimate authority to conduct those. Right
Mr.
now,
Myberg, do you disagree with that?
Mr. Elkins, I believe, is referring to investigations of personnel matters, which we believe that he has the ability and right to do, and that we encourage employees to cooperate when he conducts those investigations.
So when you initiate those, do you inform the Inspector General?
We generally ask the Inspector General, as we
Generally? How about all the time?
Pretty much all the time.
Pretty much all the time? Why not all the time?
What
are the exceptions?
When you have a matter that's a serious, and I'll use the Utro case as
No. We just said all or nothing, right? So is it all or nothing?
When we have a matter that involves a conduct that requires investigation, we ask the Inspector General to come in and do an investigation. And I will also say that from the standpoint of my career, there have been many very productive investigations that the Inspector General has done that have been helpful to conduct and discipline in the agency.
Mr. Elkins?
Yeah, the question that needs to be asked is when do they provide that information to us? What we are finding is that the agency may have the information, and then they sit on it for a while, and then eventually, yeah, it may get to us. Also, Mr. Myberg, I want to be clear that we're parsing things out here. Mr. Myberg, in all due respect, indicated on personnel matters, they do refer it, matters to the OIG. It goes much further than that. Matters not only personnel, criminal matters, any matter that has a nexus to employee misconduct should initially, as soon as it comes in the House, they should pick up the phone and give us a call. That's not happening.
Mr. Myberg?
Again, I believe that the agency has been very clear that the Inspector General, in carrying out of their lawful duties, has unfettered access to the work of the agency.
Well, they have unfettered access, but they don't know what they don't know. The process to work properly requires you, the EPA, to inform the Inspector General that there may be an issue. And that be all of the issues, not just some of them, not pretty much, not any other disqualifier. And I think what we're looking for is the administrator to clearly articulate that throughout in some sort of letter or memo or letter to Congress or letter to, without getting somebody else involved. And that's where they're bumping into other people, and that's where I think it's causing a lot of rub.
Thank you, Mr. Chairman. I appreciate that. And I'll be glad to supply for the record the statement the administrator issued within the last 6 months over the fact that employees have a duty to cooperate with the Inspector General.
Let's keep following up on that. I need to ask a couple others, in indulgence to the rest of the committee here. I'd appreciate it. Mr. Reeder, I have a question about the personnel records. Part of the challenge that we have in the specific case that Mr. Gowdy and others have brought up is that you did not go back and interview the immediate supervisor. Is somebody under consideration for a promotion? It seems like the very first person you do is go talk to their immediate supervisor, who's telling the Inspector General. That didn't happen. So the question that I have is, doesn't the personnel file, isn't there some sort of electronic record that you as a manager looking to promote somebody could go look and say, and doesn't it show up in some sort of personnel record to show that this person has had, at this point, more than a dozen women complain of sexual harassment to one degree or another?
Mr. Chairman, I think you're Mr. Chairman over there as well.
Yes.
I think, and I don't mean to offer this in defense of myself or any other actions, but just for clarification for the committee, this was a temporary assignment for Dr. Jutro. It was not a promotion, but it's not what we would consider a promotion.
Did he make more money?
No, sir.
Did his title change?
His title changed, but his position of record remained in the Office of Research and Development, and he was on a detail, which is a temporary assignment. And I don't mean, again, I don't mean that in a defense in any way, just that it's important to get the facts right. I know that you're interested in that. And it did not involve a promotion in the sense that the government considers promotions. So there was no formal vetting.
Yeah, but we're talking about 17 women who were harassed, and there doesn't seem to be a flashing red light that goes off in somebody's office to say, hey, we got a problem down here. Why does it take 17 women? Why didn't it happen after the first incident?
So in answer to your question, I think I kind of got to that earlier with Congresswoman Lawrence's question that there, I think it might be beneficial to have a better record of what actions are being taken by management that are not centrally investigated or adjudicated.
So what are you going to do about it?
I have to say the vast majority of these cases often don't rise to a level of a serious charge of harassment, but they are matters that we have to take seriously. And I mean, I have invested as much as any senior executive at EPA.
What has to happen to a woman to be serious?
If it's unwanted and it's persistent, I mean, there's a very
persistent, so if it only happens once, it's okay?
It doesn't rise to the legal definition. And
so if it happens once, if it's not persistent in your mind, then it's not harassment?
Mr. Chairman, I'm not defending harassment in any
You said it had to be persistent.
But I'm trying to tell
you qualified it with persistent, and I'm challenging that. Why does it have to be persistent?
That's what I've learned in the training from the EEOC, that it has to be of a manner that creates this hostile work environment for an employee.
So if it happens once,
that's very serious.
If it happens once, is it unacceptable?
It's unacceptable.
But in your mind, does it rise to the level? You said it had to be persistent.
It rises to a level that a manager needs to do something about it. Yes, it does. Does it rise to a level of a legal, I'm sorry, does it meet a test for dismissal or formal disciplinary action? It's all very case specific, but I have to say it's unacceptable at any level, and our managers are obligated to take action, sir.
And I appreciate the indulgence here, but your written policy says sexual harassment, written reprimand to removal. This, again, it's obviously not working, and it needs clarification. With the indulgence, one more question. I was asking if there was a penalty for watching porn, and you says it depends on what happened. I mean, how many different ways are there to watch porn? Where's the threshold where it depends?
Mr. Chairman, any amount of watching porn is unacceptable. When you were considering, you identified that there was porn, you look at all the factors that you would look at, the so-called Douglas factors, to consider in considering what penalty would be imposed. And they include the magnitude and extent of the offense, the employee's prior discipline and conduct record, and the other 10 factors that go along with the Douglas factor. That's what the table is intended to represent. Clearly, the cases that we're looking at here were very severe cases, and those exacerbating circumstances have been taken into account in the action that the agency has proposed to take.
And they still weren't immediately fired. They still were on paid leave. Here are two things I'd like you to do. One is specific to pornography. I want to see the written policy, and I want to see whatever notification you've put out over the last several years. I mean, maybe there's 20, maybe there's none, I don't know. Provide those to us in our committee. And then the definition of the sexual harassment, why the wide range? Is it a definition of persistent, not persistent? We're trying to help solve this, and that's the spirit in which we do this. We would appreciate your help. We thank you, gentlemen. I yield back.
I think the chairman, Mr. Myberg, let me follow up on one question with his, because you talked about viewing pornography. As you know, we have a bill in there that would prohibit that on federal assets and computers. So my question to you is very simple. How many hours of pornography watching is an offense?
Any pornography watching on government time, on government equipment.
Okay,
is an
so how
offense.
many of your employees would you say have this problem?
Boy, I sure hope not many.
What do you mean hope? You mean you haven't checked?
I know I have not personally supervised. the
Has
50,000
anybody?
employees? Yes, they're
So
supervisors.
can you give us the names of the people who have actually checked all the EPA employees for this? Is that your testimony? I
No,
can't believe that that
no.
would be accurate.
No, that is not my testimony.
Okay, so what's your testimony?
My testimony is that I do not believe that EPA has a widespread culture of employees.
So
watching
how would you know?
pornography. I would know because those issues would have been identified and reported to a greater degree than they have.
Well, 17 counts of sexual harassment were reported to all kinds of people, and we didn't deal with it. So do you have 17 different violations of this particular thing before it gets raised to a point where somebody retires?
I want to make sure we're clear about separating the pornography and the Peter Utro case, which was the one individual.
Well, I see them as connected, but you go ahead, you can separate them. If you want to justify pornography watching at the EPA, you go right ahead.
Let my testimony be exceptionally clear. I do not want to justify any pornography watching at the EPA.
All right, so my question still stands. How much is too much?
Any is too much.
All right, so how do you know what's being done at your agency, Mr. Myberg? Have
Hey-
you instructed anybody to check into it?
We have asked all of our supervisors to be aware and that this is.
Have you personally instructed? Can you send us an email or a memo that's sent out that says we have zero tolerance, is what you're saying today? Have you sent that out? And have you put blocks, the second part of that question, have you put blocks on those government computers?
Congressman, we have identified ways to put blocks against known port sites. We have two issues that in all candor, I have to describe. One is that the internet moves faster than we do. It moves faster identifying sites, so we clearly haven't been able,
So you're saying it's
I
a
can't
technology issue? Mr. Myberg, come on. You're saying that there is not the technology to block that on federal computers?
No, there's the technology to block sites that we know about. Sites come up faster than we can keep up with them. That is just the life on the internet.
So you have blocks on everybody's computers that, as of today, we could go and check everyone's computer and there would be a block on there for current technology. Is that your testimony?
For as many, my testimony is to the best of my knowledge that we have blocks on accessing known porn sites. I want to just elaborate.
So
on
how do these, I mean, these EPA, I mean, it's amazing to me that they can watch it for several hours and continue to get a bonus. How does the guy get a bonus?
I wish I could answer that question. I do not know.
Well, are you in charge of that?
I have not been in charge of
Is
that.
Mr. Reeder in
No.
charge of that?
Congressman, are you
In terms of
talking about an
how do
individual?
you justify a guy that's watching porn 6 hours a day and that he is still an outstanding employee and get it as a bonus? I mean, explain that to the American people.
There is no explanation for that.
So why did it happen?
Because there was a failure in the system.
So how many failures do you have, Mr. Myberg?
If I knew how many failures I had, then I'd be in a better position to give an answer.
Well, you prepared for this particular hearing. I assume you coming to this hearing was not a surprise.
No, it was not.
So when you did your research, how many problems do you have?
I have not got a list of how many problems, nor do
Can
I
you
know
get
the
that
problems
list?
I don't know.
Well, therein is the problem. If the problems are there that you don't know and you're not looking, who has the responsibility for looking in your agency, Mr. Myberg? You?
The first-line supervisors of employees are the ones who are responsible for supervising employee conduct. And that, in fact, is the point of why we need to make sure our supervisors are well-equipped.
So you're
to
saying
deal
that
with
this is all a first-line supervisor problem?
No, sir, I'm not. I think first-line supervisors need support from the senior leadership of the agency so that when they find examples of misconduct,
I
they know what
couldn't
to do.
agree more, and therein is the problem, Mr. Myberg. I don't think it's first-line supervisors that see the problem. I think it is a cultural problem that goes up to the level of Mr. Reeder here. Because when you have agencies, senior levels that are willing to turn a blind eye to the kind of horrific stuff that we've heard today, it is very troubling. Wouldn't you agree, Mr. Myberg?
I completely agree that we need to create a culture in EPA that makes it clear that watching pornography on the job is unacceptable, and that we need to support actions to make sure that people who do that are properly sanctioned.
All right. Let me ask you this. We get whistleblowers. I've gotten people on Telmark at mail.house.gov that give me all kinds of insight. I'm finding more information about your agency than you are, Mr. Myberg. Wouldn't you say that that's a problem?
That sounds like a serious problem.
And I am. And what happens is there's a culture where they don't feel comfortable talking to you. They feel comfortable talking to the Inspector General. Why would they not feel comfortable talking to you or Mr. Reeder? What possible reason would there be for that?
That I don't know, and I think that is...
I can give you an answer. If you can't come up with one, I can probably give you an answer.
Let me just state what my own view is. I do think we need to create a culture in EPA and support it at the highest levels, and the administrator shares this view, that people ought to feel comfortable in bringing things forward if they are concerned.
Well, here's the commitment. I think that it is a bipartisan commitment here, Mr. Myberg. This will stop. Because you know why? Because it actually creates a very bad picture for the hundreds of thousands of good workers. And every time you give a bonus to someone who has violated it, and you say, oops, I made a mistake, there are 3 or 4 other people who are saying, why did that person get a bonus when I'm working very hard and I'm doing the very best job that I can, and yet they get rewarded? Don't you think there's a problem there, Mr. Myberg?
Congressman, I completely agree with you that the biggest obligation, even apart from the individual actions or other kind of behavior, is the impact on other employees, because you're quite right. Employees at EPA do not deserve to be tainted by the actions of a few bad individuals.
So how many people have you fired because of that?
You
personally?
Because when you say that, could you clarify what
Looking
you
at
mean by
pornography or sexual harassment, how many people have you personally fired, Mr. Myberg? I can give you the answer. I know it, but go ahead.
This will be interesting. To the best of my knowledge, in my previous role,
I'm talking about in your new role since you've been there, you've come back. How many people have you fired?
In the last 6 months?
Yes.
No, none.
0. So is there a problem today at the EPA?
I believe that we are very clear at EPA about our policy with respect to pornography or sexual harassment, and that we will be carrying out that policy.
I believe that you have a policy, but I believe that you're not enforcing it, because Mr. Reeder, in his talking about the policy, he talked about the fact that it is up to the first-line supervisor to report that. And wasn't that your testimony?
I testified that our policy requires managers to take action if this is brought to them.
Well, when you were talking to Ms. Lawrence, I listened very intently. You said that it is important that they mention it to their supervisor, and the supervisor is to take action. That was the policy. Is that your testimony?
That's correct, sir.
Okay. If that's the policy, why would you not have checked with a supervisor in the case of Dr. Jutro?
I did check with his chain of command, so...
You didn't check with his supervisor.
I didn't check with his direct supervisor.
But the policy says go to the supervisor, so the supervisor is the only one that would really know under your policy, and yet you didn't go to him, did you?
I did assume that his senior folks in that office would have been informed of any serious misconduct. I did. And I would be more, as I mentioned earlier, I would be more explicit in that check were I to do that again. Congressman, may I address one other? You had asked about about the culture at EPA, and there is some data that addresses that. And I have to agree with Deputy Myberg that EPA does have a healthy work environment, I believe. And I do believe,
you know, Mr. Reeder, let me just tell you, we're checking into facts here.
I know.
Your opinion on a healthy environment and the reality of the facts don't line up.
Well, the fact is that EPA employees were surveyed.
I've gone way over my time. The ranking member has been very gracious. I'm going to recognize the gentleman from Wisconsin, Mr. Grothman.
Thank you. I'm going to follow up on that just a little bit. Just so you know, in my area, and we're supposed to be here looking for jobs and improving the economy, there is no federal agency that is perceived to lack common sense more and doing more to endanger the American economy than the EPA. Okay, and people, when I talk to them, always kind of wonder what these people are doing in Washington, that they're so far removed from reality when they come up with new regulations and this sort of thing to kind of penalize or hamstring American business. Now, this isn't exactly the type of hearing that I thought I was signing up for when I ran for this job. I thought I was going to be, talking to the EPA about, what are your people doing when they come up with these ridiculous ozone rules. Now we kind of know, at least what some of them are doing. How do you, is it really true, what these people are saying on here, that there were some of these people spending 2 to 6 hours a day watching porn? Is that accurate, what the testimony we're getting here?
It is accurate that we had 3 cases, or one of which was a criminal case, and then 2 other cases that were identified within the last couple of years, that those 2 employees were watching unbelievable and completely offensive and unacceptable amounts of pornography. That is 2 people out of a very large agency. And that's not to be defensive about that at all, it just is to state it.
Do you think, because that's what they were doing, first of all, that more people could be doing it, and secondly, if in their job they had the time to dilly-dally around and spend 2 to 6 hours watching porn, maybe other employees are spending 2 to 6 hours doing maybe not things that would be as interesting to the home viewing audience, but doing whatever else people do when they're not working?
Congressman, I believe from my experience with EPA that is a very, very small number, that the vast majority of vast majority, and I think the Inspector General would agree with me, the vast majority of EPA employees are dedicated and hardworking and doing the things to protect the environment for the people of this country that have produced a much cleaner environment over the last 45 years.
In the future, if you catch someone watching porn on their computer, how often do you have to have that screen up before you think they're terminated?
It's clear that the 2 cases involved, that the proposing official felt that that was more than enough information to require them to be terminated. I don't know that there's a specific bright line, because we have to consider due process and the Douglas factors in doing conduct and discipline cases. But clearly what these 2 employees did, and not to prejudge the last action, which is still an administrative process, but it was way out there.
Okay. I maybe, like a lot of people, we had other meetings going on in the building. Maybe I didn't catch. You're saying the Douglas factors. Do you think an hour a day, a half hour a day, 15 minutes a day, 5 minutes a day? What are you saying rises to the level that you feel that maybe this person should find another line of work?
Well, again, to be clear, any amount of watching pornography on EPA computers on EPA time is unacceptable. The question then becomes, what level of sanction would you impose as a result of that?
Right, that's exactly right. And if we find that somebody has been watching porn for an hour a week, a half hour a week, 15 minutes a week, at what point do you think they should no longer be working for the EPA? If you just had to give us a wild guess.
I'm hesitant to do that about any specific cases, but some of the kind of upper numbers that you mentioned would cause grave questions for me if I were their supervisor, why that person should be working for EPA.
Okay, how about the lower numbers I mentioned? How about a half hour? You think a half hour is out of line?
There would be consequences and discipline associated with that. Again, and I don't want to make it sound like I'm being splitting hairs or being overly complicated, but each one of these cases has to be considered individually.
I tell you what I'm going to do for you, just because, this is not an area that I'm an expert in. Next time I go back to my district and I tour my local manufacturers that are being, really threatened with their existence and throwing all their employees out because of what the EPA is doing, I will ask them how many hours a week or half hours a week or 15-minute slots a week of porn they allow their employees to watch before they terminate them. So you kind of have kind of know what the average company out there feels is a good policy. And I'll get back to you on that, and then you'll have some direction. Is that okay? And I appreciate you spending the time today.
Thank you, Congressman.
I thank the gentleman. The chair recognizes ranking member of the full committee, the gentleman from Maryland, Mr. Cummings.
Thank you very much, Mr. Chairman. Gentlemen, your day with us is just about ended. But I got to tell you, if I were watching this, Mr. Myberg, just look, watching C-SPAN, I'd be disgusted. We're better than this. We are so much better. Just think of the idea of the sexual harassment issues. You married? You married, Mr. Myberg?
Yes, sir, Mr. Ranking Member.
The idea that your wife would come to work after doing all the things she has to do to get ready in the morning and take care of her family, and then she got to come and be harassed. And then it seems as if the powers that be don't address those issues when they find out about them. Man, you go crazy. And I tell you, and then, I was just thinking about what a negative, all of this has on the morale. Chairman, you talked about it a minute ago. The idea that you've got these folks who stay in the employment of our EPA after having done these things. And I just can't get past what you told me a little earlier about how you were waiting. You guys were waiting for the U.S. attorney, and come to find out you already had permission to move forward on the pornography cases. Something is missing. And we are better than this. We are so much better. And if you can't do the job, you need to let somebody else get in there and do it. Because a lot of people are depending on government functioning properly. They just want to come to work, do their job, give them their blood, sweat, and tears, and then go home. But then their morale gets destroyed when they see people coming back to work. They don't get, just a little tap on the hand. Come on back. Welcome. Let's watch some more porn. Come on, give me a break. This is crazy. We're better than this. Do you agree?
Congressman, I absolutely do. And the point that you made is that the people who most deserve that we take action on cases of folks who are engaged in terrible conduct, the ones who most deserve it are the employees of EPA. And I want to make sure I'm clear on a couple of points.
Yeah, be clear, because
I
got to tell you, man, I'm a bit concerned here.
Well,
because I don't feel the sense of urgency. No, yeah, that's right. I said I don't feel the sense of urgency. I do not feel the sense of significance. I don't feel the sense of, the only reason I mentioned, asked about your wife is because, you just seem, I think sometimes people need to flip things and think about, how they would want their relatives to be treated or their daughter. You follow what I'm saying? So I was trying to get some of that urgency out of you, and I'm working on it.
Well, thank you, because I think that would be an appropriate sense to get from me, is that sense of urgency.
Yeah, I wanted to paint a picture for you.
Yes.
Because sometimes maybe, we may be meant, but when you think about somebody you're close to, somebody you love, somebody who supports you, somebody who has your children, go ahead. Now we got you at the urgency level now, I guess.
No, absolutely. And
okay.
The fact of the matter is, watching pornography on government time and on government equipment is prohibited by EPA policy, and we are indeed urgent about that because employees who engage in such behavior will face disciplinary action up to and including removal. And EPA is going to, in doing that, and one thing that hasn't come out in this hearing, I do want to make a point. In doing,
Make it quickly, because I got
Okay.
I got just a few things else I need to
Okay,
ask.
EPA wants to follow the law, and part of the reason we want to make sure we follow the law in these things is so that actions that we take are sustained on appeal to either the Merit System Protection Board, the EEOC, or in the district court, because the consequences of an action that we took where we removed somebody and then that action was overturned would be pretty bad.
I got you. The Merit System Protection Board submitted a statement for today's hearing stating that current law permits an agency to take adverse employee action, including removal based solely on an employee's sworn statement or admission, and several MSPB decisions are cited. The I'm sorry, Mr. Chairman, I would ask that it be admitted into the record.
Without objection.
That'd be helpful.
Thank you. Do we have an extra copy for him? Oh, you have it. Huh? Oh, no, I want this gentleman, I want you to have it, Mr. Myberg. I'm going to get you a copy of it. But the MSPB has determined that, and I quote, an agency may rely on an appellant's admission, and this is a quote, in support of its charge. So, Mr. Myberg, help me with this. Why wasn't this employee's detailed admission of downloading and viewing pornographic images on EPA equipment over the course of years sufficient to initiate a removal?
Congressman, I don't mean to be evasive, but I can't speak to that particular thing. I do think, and I have urgency about this, that we do need to work better with the Office of the Inspector General and with the Department of Justice and U.S. attorneys to make sure we ourselves clearly understand. So we have work to do. We understand that.
Okay, but were you familiar with what I just talked about? Were you not necessarily the document, but the fact that you could do this?
No, this is actually new information to me.
Did you know that, Mr. Sullivan?
Yes, sir, I did, Mr. Cummings, and we communicated that to the labor and employee relations attorneys that we dealt with continually on both these cases, that you were free to take action and that you certainly could take action. But they chose to wait until the very end, and it's inexplicable to me. I don't know why they did that.
Mr. Myberg, we got to do better. I'm sorry. This is not acceptable. It is not acceptable, and I feel sad about it. And and listen to me, man. You ain't got to say nothing. I'm almost finished. I feel sad about it. Because I mean, you got Mr. Sullivan and Mr. Elkins, and I think I was a little hard on you all in my opening statement. And I didn't mean, and now that I look back, it's not your fault. You did your job. You did what you could do. You gave the advice, you tried, but then it seems as if you were hitting brick walls and trying to accomplish what you wanted to accomplish. And for that, I apologize for what I said earlier. Because I couldn't figure out why things weren't moving fast enough. Now I know. Now I know. And you know who it is? It's you, Mr. Myberg, and you, Mr. Reeder. And there's absolutely no excuse for it. I'm sorry. It just isn't. And so, and this is the last thing, Mr. Chairman, thank you for your indulgence. Earlier I asked for a commitment of the EPA and the IG to work together to share admissions of employee misconduct. And Mr. Myberg and Mr. Elkins, you both agreed to do that, and I think you did. And I just want you to keep, the chairman and I, you keep us informed of your progress. And you are going to start working on that immediately? Can you, somebody?
Yes, we'll do that.
Did you?
Yes.
Okay. And can you give me some date when I can expect an answer? Because I don't want to wait too long. Can we get, I want a date now. Give me a date.
Let's see this. We will work together with the Inspector General, and we will get you a follow-up on that by the end of June.
What'd you say?
The end of June.
Why is it going to take so long?
I want to make sure that we are doing this.
Mr. Myberg,
Yes, I'm not trying to.
Mr. Myberg, tell you what, make it the end of May, all right? To me, that's too long. Okay?
Yes, sir.
End of May. Will you try?
Yes, sir.
And if you're having difficulty, would you let us know? You can contact the staff or send us a letter if you're having difficulty getting together, because we expect something by the end of May, all right?
Yes, sir.
Thank you all very much.
Thank you.
I think the gentleman, before he leaves, I want to make one comment. We were discussing and talking about employee morale, and there's no one more committed to the federal workforce than the gentleman from Maryland. But it also shows to his character, Mr. Elkins, Mr. Sullivan, when the ranking member is willing to apologize for perhaps being overzealous, and that just speaks to your character, Mr. Cummings. I just want to thank you for that. Mr. Myberg, I want to be very specific. You know, a lot's been talked about, and I understand that you have a zero tolerance for porn watching. But in light of the revelation that the ranking member just provided to you, that you have the ability, not only the ability, the requirement to address these kinds of behaviors. I'd like to know from you today if we have a EPA employee who is watching porn, and let's pick an hour a week on average. Are you willing to fire them? Yes or no?
I am not willing to make a judgment on an individual case without.
If they admit that they've been watching it and you find it on their hard drive, are you willing to fire them? Yes or no?
I will answer for myself.
You're the head of the agency, one or two down. You can answer for the agency. Yes or no, will you fire them?
If we have an employee who's watching, and I'll go with your scenario, if we have an employee who's watching an hour a day of porn, and that is documented, and by the whatever forensics we need to do to document that, that seems to me it would be an appropriate case for proceeding with termination.
That's not a yes or no, Mr. Myberg. That is a question with a question. My question is very specific. If they are watching porn for an hour, it's a low threshold. I mean, most of the others, I wouldn't even tolerate that.
No.
Would you fire them?
I understand that, and like I
yes
said,
or no?
I would fire them.
Will you instruct your departments to fire them?
I will take that information back and, no.
Yes or no?
It's not a yes or no.
There is a yes or no to the end of this question, and we're going to get there eventually. So if the answer is no, just tell the American people no. Because that's what I'm sensing is the answer is no.
I don't think that's fair, but I also don't think it's fair to me to prejudge every case that would come before a supervisor or before the agency. And I'm sorry that that's not a simple yes or no answer, but it's just not.
So the answer is no.
The answer is not no, and the answer is not in every case.
Mr. Myberg, let me just tell you, I know they brought you back and you had a stellar career at Region 4 and other places. But I can tell you, you're doing the EPA a disservice today. If you cannot, before the American people, admit that watching porn is offensive enough to fire them, moms and dads all across America don't understand that, and quite frankly, neither do I.
Congressman, I completely agree that watching porn on EPA computers and EPA work is not
But
acceptable.
if you don't do anything about it, Mr. Myberg, it will never change. And what I'm hearing from you today is that you're not going to do anything about it, and I am saddened to hear that. Mr. Sullivan, Mr. Elkins, I want to thank you for your work. I want to also let you know that the ranking member and I were talking about this. I know the chairman, Chairman Chaffetz, is not going to let this go by the wayside. If you will continue to follow up and do your work, please thank all of those who work with you. The other is if we do not get clarity by the end of May, as the ranking member has suggested, on working with you, we are asking you to report back to this committee of any potential problems. Mr. Elkins, are you willing to do that?
Yes, sir, and thank you for your support.
Well, you have it. I would also suggest at this particular point that there would be a 72-hour, Mr. Myberg, if at 72 hours, if you have an employee issue, that you would notify Mr. Elkins within 72 hours, your supervisors or anyone else, on anything that may be of a concern, and let the Inspector General determine whether it needs to be something that needs to be followed up on, not just those that you think are important. Wouldn't you agree that all, as your previous testimony would indicate, need to go to the Inspector General?
Again, my testimony is that my own experience in going to the Inspector General.
I don't care about your own experience. You'll be long gone eventually. Should the agency have a commitment to refer all, A-L-L, all, to the Inspector General? Yes or no?
Not, again, not to parse hairs, but when you say all, are you referring to all issues of employee misconduct?
Yes,
specifically?
all issues of employee misconduct or potential employee misconduct. All, A-L-L.
The reason I am hesitating, and again, it's not to parse words, is that
Well, you are parsing words,
I know.
and so I would suggest that you get somebody else to come and testify the next time around. Mr. Clay, if you would, we'll recognize you for 5 minutes of questions.
Thank you so much, Chairman Meadows. And I know that some of this ground has been covered already, but I'd like to focus on the case of the GS-14 Environmental Protection Specialist. Help me with the timeline. On May 2nd, 2014, the IG received allegations that this employee was viewing pornography at work. On May 8th, the IG interviewed the employee and took his sworn statement. On June 19th, the IG provided the EPA with a copy of the employee's sworn statement. It took the IG about a month after the statement was given to provide the EPA with a copy. That is a quick turnover compared to the case of the geologist. Despite receiving the sworn statement on June 19, the EPA did not start the process of removing him. Instead, a dialogue ensued between the EPA and IG over the next 10 months regarding additional evidence. On February 23, 2015, the U.S. Attorney's Office for the District of Columbia declined prosecution of this case. The IG communicated this to the EPA in its final summary memorandum report on March 13, 2015. After this happened, the EPA acted quickly, issuing a notice of proposed removal on March 23, 2015. And this case is currently pending, so we cannot delve further into the detail. But it is difficult to understand why the EPA did not go forward with removal proceedings as soon as it received the admission. At that point, these were no longer just allegations. They were admissions by the employee himself. Yet, here we are, it's nearly a year later, and the employee's removal is still pending. What I'd like to hear from the panel is whether there's a way we can handle similar cases more effectively and efficiently in the future. And Mr. Elkins, I'll start with you.
Yes, sir. Thank you for the question. I think initially in our conversations and, after we completed an investigation, we immediately, timely have a conversation with the agency as to what our findings are. At that point, once we turn it over to the agency, it's up to the agency to act on it. In the past, we've had discussions about what an admission means, what the culpable level of standard of proof. We have that discussion, so we've gone through this many times, with the agency. But once it leaves my shop and we give it to the agency, we're dependent on the agency to act.
Mr. Sullivan, anything to add?
Mr. Clay, no, I concur with Mr. Elkins, and we acted appropriately in this investigation. And not only do we turn the report over within a month, immediately after we interviewed the environmental specialist, we verbally briefed his supervisor as to the results. So within a day of the investigation beginning and the interview being conducted, we verbally briefed the supervisor, and then we turned over the confession within a month.
Okay, well, take it from there, Mr. Meeberg.
And to make to that point, one of the things we have discussed in this hearing this morning is that perhaps EPA needs, not perhaps, EPA needs to look back at its own internal procedures to enable us to proceed based on the admission without waiting for the final conclusion by the Attorney General's office about whether or not they're going to accept a matter for criminal prosecution. That would have speeded this case up.
Okay, where is it now? Is it?
Let's see, which one?
Is the employee still there?
I'm trying to remember which employee. There were 2 employees. I'm trying to remember which one.
This is the GS-14 Environmental Protection Specialist.
Where that is that the agency proposed removal of the employee. The employee, as is his right, contested this and is going to a hearing with the deciding official today.
I see. Mr. Reeder, anything to add?
No, Congressman.
Okay, let me pose this question to the entire panel. What can we do to get all of the necessary evidence to the agency more quickly to facilitate quicker removals in cases where the individual has admitted serious misconduct? Mr. Elkins, we'll start with you.
Yes, sir. One of the issues here is that once we have provided our evidence to the agency, what we hear in many cases that the agency says, we don't have enough evidence. So give us more evidence. And again, when you have an admission, you don't need much more than that. And also, we're not talking a criminal case where the standard of proof is proof beyond a reasonable doubt. It's a preponderance of the evidence. When we prepare a case, and that case is going to the U.S. Attorney's Office, we prepare it to meet the burden of beyond a reasonable doubt. When we turn it over to the agency, it's a lower standard. So they've got everything they need, but yet what we hear and what we've heard from the agency is give us more.
Now, did the agency ask you, tell you that in this case?
Yes, I believe in most of the cases that I've been involved with, that's what I've heard.
Okay, Mr. Meeberg, tell me why the agency needed more evidence after you had an admission from the employee.
Congressman, I can't speak to this particular case on that matter. As a general matter, the agency has wanted to make sure that we weren't taking any action to interfere with a possible criminal prosecution or with the Inspector General's investigation, which was not the issue in this case, and to make sure that we had enough information so that when we took a final action that was subject to review, that it would be sustained either administratively or in the courts. Our worry, our fear, if you will, is that actions that we take are overturned, which would result in not only having to pay back salary and attorney's fees and possible penalties, but then the employee ends up being reinstated in the agency, and that would not be a happy outcome.
Mr. Reeder, okay, so now this employee is going to an administrative hearing to contest his firing?
I know that only because of Deputy Administrator's testimony. I am not familiar with this case.
You're not familiar with this one. My time is up, but thank you for your...
I thank the gentleman from Missouri. If there is no further business before the committee, I'd like to thank all the witnesses for being here today, and this meeting of the Oversight Committee is adjourned.